This is a meeting of the Athens Board of Zoning Appeals. The time is 7:01 p.m. and the date is July the 12th, 2011. At this time, I will call the meeting to order. The board consists of 5 members and 2 alternates, the alternates taking full part in the discussions and becoming a voting member in the absence of a member or when a member abstains for conflict of interest. Present tonight are members Betty Hollow, John Golsey, Greg Lavelle, Michelle Drabel, myself, John Kronansky, and alternate Kay Tousley. It's a long, hot summer day in Athens. And I am John Kronansky, the acting chair. Also present are Zone Administrator John Paskey and Secretary Paul Eschenbacher. The board operates according to the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and render a decision. According to Athens City Code Section 230703B, the board has power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code Section 230910C, variances from the code should not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions have been supported. Practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public good. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone in the same vicinity, while a granting of a requested variance will not confer on the appellant any special privileges that is denied to other properties in the same zone in the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. There are 2 cases on tonight's agenda. The first case, case number 1109V, appellant Laura A. Larson. Case 2, 1112V, appellant Teresa A. and Kurt R. Montel. The board is required to take testimony under oath. Would anyone wishing to speak concerning any item on the agenda please stand? Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. The first case, and this case was continued from last meeting. And that is case 1109V, 134 Grosvenor Street, Laura A. Larson, appellant. And the appellant's requesting a variance from ACC 2310-01, Table A, schedule of bulk controls to allow construction of an attached deck to a house with total lot coverage of 40%, where 30% is the maximum allowed, and from ACC 2308-01 to allow elimination of one on-site parking space where the requirement is to retain on-site parking. Mr. Eschenbacher or Mr. Paskey, would either one of you want to speak to this?
Well, if you remember from the last meeting, the reason this case was continued is we wanted to make sure we had an accurate measurement of where the deck would be on the property and if it would affect the one parking space. The week after, I went to Ms. Larson's house and inspected, and indeed the deck will jut out approximately 4 feet into that parking space. So those support posts, once they go in for the deck, will effectively be in the middle of the parking space, thus rendering it useless. I'd also like to add that in doing my measurement there, I would question whether that could actually be called a parking space. It's closer to 8 feet wide than 9 feet, although I imagine it could be widened if necessary on that spot, even though that's about the only flat part of the back there. And also, even though the alley there has a 16-foot wide right-of-way, the alley is narrower than that and not in the greatest shape. And it does say in there that one of the requirements for parking spaces is that they have adequate ingress and egress, and I would question if anything larger than a mini car could adequately use that space as it is now. So that's all I had to say if you have any questions.
And so it is, the code office determines egress.
It just says adequate. There's no specific other than when it gets down to the width of driveways and width of access to it. Technically, I suppose it could be used, but it's certainly not for anything above a small car.
It's very steep, too.
Yes.
Board members have any more questions for Mr. Eschenbacher?
No.
Okay, will the appellant like to come to the podium? And state your name and your address, please.
My name is Laura Larson, and my address is 134 Grosvenor Street.
Would you like to speak to the variance request, or?
Mostly just to sort of reiterate what I included in the document and what he said. The deck will come into the parking space. I've owned the property for 4 years. I only once attempted to use the parking space, and I had to have my car towed out. It was that steep, and I have a very small car. So it is not a functional space in the sense that access to it is simply not there. It is a non-conforming lot. It is a very, very small lot, and the residence, as of now, takes up 32.7% of the lot. Since we do live on that steep ridge, I do not have any kind of outdoor property. I don't have access to any sort of outdoor space, and I have a small daughter, and it would be wonderful to have a sort of outdoor deck where I could, she could play outside safely and sort of within reach of the residence. You may recall that the deck is going to open up from the kitchen.
So the front of the house is fairly close to the street.
It's very close.
And when you bought the house, you have always parked in the front. I mean, you kind of bought it knowing you would have to park on the street.
Yes, and I actually, I rent a parking spot too, just to sort of keep my car safe, essentially.
Right.
Okay, well, if you have no further comments, then thank you.
Thank you.
Is there anyone that wants to speak in general comment regarding the variance? Anyone who would like to speak in opposition? Ms. Larson, you want to make any additional comments before we close the floor? Okay. Well, somebody want to make a motion?
Yes. I move that we grant a variance to the property at 134 Grosvenor Street from ACC 23-1001, Table A, Schedule of Bulk Controls, to allow construction of an attached deck to the house. Have we got those dimensions, just so we could put it in the motion?
10 by 12.
Okay. Let's see, an attached 10 by 12 deck attached to the house with a total lot coverage of 40%, where 30% is the maximum allowed, and from ACC 230801 to allow elimination of one on-site parking space, questionable parking space, where the requirement is to retain on-site parking.
Second?
I'd second.
Okay. Let's go through the findings unless anyone wants to have conversation. Okay, practical difficulty and undue hardship. Well, I think it's clear that the lay of the land makes practical difficulty in terms of use of the rear of the property. This may be the only level spot besides the sidewalk in the front of the house. And also the house is placed very near the front of the lot.
It's a owner-occupied house, too, which in that particular part of the street is well sought after. So, I don't know if that's an appropriate comment for that statement, but for that.
And in terms of the parking, obviously it's almost impossible, or maybe is impossible, to even use it or consider it as a parking place. Exceptional circumstances?
Well, you've already addressed some of those. The lot is extremely steep. It's extremely small as well, and the parking lot, the parking space is accessible through an alley that's really in terrible shape, almost inaccessible.
Preservation of equal property rights.
Others have equal size, porches, decks in the backyard.
Well, since her parking space is really not usable now,
Accessible.
she in effect bought a house that really had no parking, and there isn't any way to provide any parking for this house. So I don't think anybody else can complain if they're in this, what they think is a similar situation. This seems to be a rather
Unique situation
Yeah.
in terms of that particular piece of property.
very small lot, steep back.
And we also need to argue the 30% versus 40% coverage also.
Right, again,
because-
but the lot is extremely
Yeah, it's small, yeah.
Even in that neighborhood, it's small.
Minimum variance, the variance granted is the minimum variance required to make possible a reasonable use of the property.
I think 10 by 12 is a reasonable size,
small.
so it should be minimal.
Yes.
Yeah.
Not of a general nature.
No.
No.
Yes.
Okay, call for a vote. Greg Lavelle?
Yes.
Yes.
John? Betty?
Yes.
Yes.
Michelle? And I vote yes. Motion passes. You have your variance. The next case before the board is case number 1112V, 9 North May Street. And the appellant is Teresa A. and Kurt R. Montel. Mr. Eschenbacher, do you want to give us any information that we haven't
It
already
seems to be
received?
pretty self-explanatory. I guess the only thing I'd want to add is there are no previous variances for this property. So if you have any questions.
Will the appellant be speaking? Okay. And state your name and your address.
My name is Kurt Morrow of 9 North May Avenue.
Would you like to present any information to the board?
Yeah, I have just some general pictures, give you maybe a little better concept in the drawing. Additionally, I have a letter in support from the adjoining property directly against that from Carol Blue of 11 North May.
Can bring that forward. Thank you.
The pictures, there's some before and after pictures there of the residents. We're in the final stages of doing renovations to the property. Doing some external renovations is the last process here this summer.
You mentioned in your letter that the intent of the proposed construction is to transform the existing outbuilding into a usable space for the enjoyment of the homeowners. Can you be more specific that exactly how do you want to use that space?
Sure. The last two pictures you have there are profile pictures of the building. My assumption was originally the driveway led directly to this building. It's extremely small, like 13 by 20 approximately. So I assume the intended use was a garage. It's just really not applicable to use it as a garage. It's very small, poorly situated on the property, all the way to the back, etc. So the intent of the variance, what we're doing is creating a patio area to create a usable space for the structure. Right now, the only thing we're using it for is storing the lawnmower in it. It serves no purpose for the property. It's very outdated, etc. The only other option I perceive would be to simply to demolish that building and to build something in addition. And because of the small lot, it's a 50 by 125. I'd be standing before you again asking for that variance because I would be encroaching upon the property lines. So from our perspective, this is the minimum we could ask from the board in regards to a variance to be able to use the property to its fullest extent.
And by using the space as you're requesting, you will not be extending the footprint any larger than what the garage space is at the moment?
What we're requesting is extending the footprint towards North May by 12 foot with an additional 2-foot overhang. So the footprint will increase with this application.
So the patio will be covered, but I assume that the sides will be open.
The sides will be open, exactly. It'll be an open patio area.
So you're increasing the roof, but not the walls?
Correct.
Does anyone have any?
I had a question for Paul maybe, or John. Accessory buildings, you still can't live in them, right?
Correct.
It's not you cannot live physically in there.
Not in this,
Accessory.
the only rare exceptions are like servants' quarters.
Okay.
I don't think there are a lot of those in Athens, right?
Thanks.
Okay, well, thank you. Is there anyone that would like to speak in a general nature regarding this variance? Yes.
Can I speak for?
Well, that's next. Would anyone like to speak for? Okay, would anyone like to speak in favor of the ordinance? Did we actually swear you in initially when I was swearing in anyone who chose to speak?
No, you did not swear me in because I thought you only wanted the stakeholders.
Oh, no, we'll have to swear you in also. I'm looking for oh, here we are. The board is required to take testimony under oath. If you are speaking could you attest to the following? Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth?
Indeed, I do.
Thank you. Now, you want to state your name and your address, please?
My name is Howard Federspiel. I live at 10 North Shannon, which abuts the property in question. The structure that is being, would be added onto comes right up to the edge of my property. But it's not on the other side that the addition is. And I have no problem with the structure the way it is. We've managed to work that into the scheme of things. And I would compliment the Montals for their cooperation with me and with the neighbors in restructuring this property. They've taken a piece of property that was worth some money and added immensely in their renovation efforts, which have been careful and took due cognizance of the rights of all of the neighbors. And I speak probably for the other neighbors who didn't bother to come this evening in that regard. So we're very pleased with the way he's done this. I would point out that the original living area, the footprint that was there before that served as a patio, was taken out by the Montals early in the game. So all you're doing is really moving that footprint from one side of the property to another place. So you're not really increasing it at all, I don't think. So that's an important factor. And I think you already have a letter in support from the neighbor who is most clearly involved, which is to the north of the property, and they would be the most affected by it. And I know of no complaint from that quarter at all. In general, I can say that I think not only do I support it, but probably my neighbors do as well. I've heard no complaint about this. As soon as they've discovered what it was about, they said it's fine. So there'll be no repercussions on the street on either my street or on May Street from this change.
Well, thank you, Mr. Federspiel. Would the appellant like to make any additional comments?
I have a couple, if you don't mind.
Sure.
Just a few brief points that I felt to mention that we had in our letter. The adjoining properties at 7 North May and 11 would be similar size structures as to what we're proposing. They're older structures, obviously, but they don't meet the setback requirements as they exist today. So the size of the structure, I just wanted to emphasize, really wouldn't be out of context or out of the ordinary in regards to adjoining properties. The other point I wanted to mention, I know there was a variance requested for a nearby property at 13 North May for Mr. John Soul. I feel as this is relatively similar. They're so small and extremely restrictive in what we're allowed to do in trying to comply with the city's requirements. Thank you.
Thank you. And we do have one letter from a neighbor, and it's short, so I'll read it, and we can include it in the record. Dated June 27, 2011, City of Athens, Code Enforcement Office, Athens, Ohio, to whom it may concern. I live at 11 North May Avenue and have talked with Kurt and Teresa Montel regarding the proposed changes they wish to make to their garage at 9 North May Avenue. Those changes will not affect my property, and I concur with them to proceed with their plans. If you have any questions, please contact me. Carol Blue, 11 North May Street. Well, if there's no other discussion, we'll close, and the board will discuss the situation. Someone want to make a proposal?
Just make a motion.
Yep.
I move to grant a variance to the property 9 North May Avenue from ACC 230311A1 to allow construction of an addition to an accessory structure with a side setback of 2.33 feet and a rear setback of 0 feet, where 5 feet each for the side and rear setbacks is the minimum requirement.
Second.
You want to have any conversation before I read the findings?
Yep.
Good. Let's go. Let's go. Practical difficulty and undue hardship.
Well, the placement of the outbuilding is such that, it was approved back in the old code, but certainly wouldn't be able to meet the requirements of the new code, and simply wants to extend the roof out in order to cover a patio area.
Exceptional circumstances.
Similar with the size of the lot.
Size of the lot.
And the size of the garage, which apparently can't really be used as a garage.
As a garage.
The outbuilding.
Preservation of equal property rights.
We recently approved something quite similar to this, so, and the neighbors seem to be in agreement.
And other residents have smaller lots with same situations. Minimum variance.
It's not going to be a huge change to the property.
Yeah, he's just adding a roof, basically, roof line,
The roof line.
no additional structure.
Absence of detriment,
No.
and definitely not of a general nature. Okay, I guess we'll take a vote. Greg?
Yes.
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 And I vote yes. You have your variance. Would you like to have your pictures back? You want to take?
Well, actually, I just want the letters.
I have a letter for each other.
Just resubmit.
Okay, I think at this time, we should approve the minutes of the June meeting, and then we'll go into executive session.
I move to approve.
Second.
All in favor?
Aye.
Aye.
Madam Chair, if you're prepared to move on to the executive session, I wanted to address the board just for a moment, if that's all right.
That would be fine. Pat Lang, City Law
Members
Director.
of the board, yes, Pat Lang, City Law Director, just to follow up on the brief presentation that I gave last week. I know many of you are interested in having an opportunity to sit down as a group and discuss the litigation. Unfortunately or unfortunately, to do so in a confidential setting would violate Ohio sunshine law under most circumstances. However, there are several exceptions under which the board can meet in what's called an executive session, and pending litigation being one of those circumstances. This is something that you'll see City Council do from time to time to discuss litigation involving the city at large. In this case, the board itself is a defendant, as are several of you who were on the board in 2008. And so this would be your opportunity to discuss both with myself and with Mr. Chuck Curley, who's joined me this evening as is also an attorney on the case, and to answer any questions that you would have. So in order to go into an executive session, that requires a motion, and that motion must include the names of everyone that you would like to be included in that session. So in this case, that would be all members of the BZA, as well as Mr. Paskey, myself, and Mr. Curley. Is Paul going to be here, or did he leave? Okay, so there would just be the three of us. And then so we need that motion, a second, and then an individual roll call vote, just like you would on anything else. And at that point, then we can immediately go into an executive session and discuss the litigation.
Okay, so I can just make that motion?
Yeah, are there any questions about the procedure for going into a... Okay, great.
Okay, I move that the Board of Zoning Appeals, Betty Holland, John Golsey, Greg Lavelle, Michelle Draybold, Kate Towsley, and myself, the acting chair, along with John Paskey, Patrick Lang, and Mr. Curley, move into executive session. Second?
I'll second.
Greg?
I say yes.
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 Oh, I'm
Yeah.
sorry. I hate to interrupt, there was, Mr. Curley pointed out the one thing I did, we must mention that the purpose of the motion is to discuss pending litigation. I said that in my intro, but yeah, we need that as part of the motion as well, so if you wouldn't mind us doing that.
So if I might include, the purpose of the session is to discuss, what are we discussing?
Pending litigation.
Pending litigation.
I'd second.
Thank you, sir.
Yes.
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 Yes, and yes. So, we now move into executive session, and,
Yeah. And so we can go ahead and we can maybe say, give 1 minute, at which point, after coming out, then you would adjourn. I believe that's the last thing on your agenda this evening. Is that correct?
yes, correct.
Great. All right.
So we're adjourning
Okay.
at 7:31.